on the East Coast of the United States. Welcome to False Claims Act Implications for M&A Transactions. We're happy to be here with you today and looking forward to having a good discussion about how the False Claims Act can get in the way when you're buying or selling a company. First things first, a little introduction. My name is Matt Feinberg. I'm a partner in the Litigation and Dispute Resolution Practice Group at PilieroMazza. I handle a wide range of False Claims Act matters from the very beginning when we're identifying False Claims Act violations before anyone else has found out about them, through the investigation process, and then through litigation. I speak a lot on False Claims Act matters, and you've probably been to one of my webinars before. Today, I'm joined by my colleague, Kristen. Kristen, you want to introduce yourself?
Yes, thanks, Matt. Hi, everyone. My name is Kristen Center. I'm a partner in PilieroMazza's Business and Transactions Group. My practice includes representing businesses, private equity firms, capital providers, family offices in M&A transactions and corporate restructurings, both on the buy and sell side. Another part of my practice is frequently serving as outside general counsel to startups and private equity companies in a variety of industries. For example, insurance, software, tech, retail, and of course, government contracts. And I represent these clients with general corporate and contract needs. So happy to be here, and I'm looking forward to a good discussion.
Awesome. So you've got some people on both sides of the deal life cycle here. Kristen, who handles basically from start to finish, and then I handle the kinds of stuff that happen afterwards. So feel free to use the questions box, ask any questions you may have. We're happy to jump in and answer them. But before we get started, I want to give my legal disclaimer. Kristen and I are not giving legal advice to you today. Your specific circumstances may be very different than the examples that we give today, and all circumstances are not the same. So we're not creating an attorney-client relationship, and we're not providing legal advice specific to your circumstances. If you do have questions for us specific to your own individual transactions or circumstances, our contact information is on the PilieroMazza website, or it'll be on the last slide of today's webinar. But feel free to reach out to us separately, and we'd be happy to get back to you with some answers to your questions. Meanwhile, here's our shameless plug. This is what PilieroMazza does. Feel free to reach out if any of these things are piquing your interest, or if you have issues that come up that deal with any of our practice areas. All right, so let's get started with a little bit of background on both the FCA and M&A transactions in general, so that everybody's working from essentially the same starting point. This is a slide you've probably seen before if you've visited one of my FCA webinars before, but the FCA is the government's primary vehicle to collect money obtained through misrepresentation or to retrieve money improperly withheld from the government. It primarily affects government contractors, subcontractors, vendors, suppliers, and other companies that exist within the public sector supply chain. But it also, keep in mind, affects anyone that, like grant recipients who are receiving federal funds, or if federal funds are involved in a transaction. And obviously, that includes things like healthcare fraud, where there might be money paid by Medicare or Medicaid. Some quick definitions for you. When we're talking about an FCA violation, we're ultimately talking about what's called false claims. A claim is a request or an obligation related to money or property. You're typically going to see that as an invoice, a pay application. It could also be a submission for indirect rate adjustments, things like that. Anything that's tied to money that would be paid or withheld from the government. False seems like a straightforward definition, but it's a little more broad than you would imagine it. It generally means that the entitlement to whatever money you're seeking or withholding from the government was improper, incorrect, unlawful, or unjustified, or it may otherwise be proper, but it is supported by a misrepresentation, either expressly or impliedly. But not all incorrect claims result in violations of the False Claims Act. There is, if you're a fan of Legally Blonde, a mens rea requirement, a mental requirement, or an intent. And the intent requirement with the False Claims Act is threefold. It's either actual knowledge, where you have awareness that your conduct is wrongful, Deliberate ignorance, which we define as sort of sticking your head in the sand while there's a bunch of fraud going on around you, so that you can avoid knowing exactly what's going on, but you submit your claim anyway. Or reckless disregard, which means there's a reason for you to question whether there's some fraud going on around you, but you don't take the steps to inquire, or you submit, knowing that there's this risk, you submit your claim anyway. These concepts all seem a little straightforward, but FCA violations can take many forms, and we're going to talk about that on a future slide. But we're not going to go into the, this is going to be a deep cut into what is an FCA violation. There are other webinars I've put on and that PilieroMazza has sponsored that you can go to get sort of an understanding of the deep details of an FCA violation, but we are going to cover some very quickly and then talk about how they affect M&A transactions in particular. The other thing I would mention is there are civil and criminal components to the False Claims Act. Now, typically you're going to deal with a civil False Claims Act violation, but if the violation rises to the level of intentional conduct or an intentional defrauding of the government, you can see criminal activities for wire fraud, mail fraud, or making false statements to the federal government. And so those are always something that you want to take into consideration in any M&A transaction. We're talking about the severity of the potential liability.
Great. So now we're going to talk about the various types of M&A transactions that are relevant to FCA claims and how liabilities can carry over to the buyer. So one type of M&A transaction is an equity acquisition. And this is when a company sells its stock or its units, if it's an LLC, to a buyer. And when the transaction closes, the buyer by default becomes the owner of all the assets and liabilities of the target, either known or unknown. And so for purposes of this presentation, I'll refer to equity deals and stock deals as one and the same. In an asset acquisition, the seller retains ownership of the target company's legal entity. And the buyer really only takes on certain assets called cherry picking. You'll hear that sometimes in an asset sale, and agrees to assume a certain set of liabilities, such as obligations under assigned contracts or liabilities incurred in the ordinary course. A third type of common M&A structure is a merger. And simply put, this is just when a merger or when a company merges up into another entity and the non-surviving entity no longer exists as a legal entity. I'll note here that there are a lot of tax considerations that parties usually consider to determine which structure to go to. But for purposes of this presentation, we're not going to get into the weeds about the tax implications on these various structures. Okay, so now we're going to talk about how the FCA impacts the M&A transaction. And this kind of caters to or depends on the type of the deal. In a stock sale, if a company acquires, if a buyer acquires a company, that means it becomes subject to the liability. That's under the concept of successor liability. And an asset acquisition, when a buyer assumes a contract, the target company or the assignor is not automatically released from the liability. The signer is in fact only secondarily liable unless the other party to the contract expressly agrees to release it from the liability. And that's called a novation. And just for purposes of background, and Matt will touch on this a little bit later, a novation is a three-party agreement where the assignor is released, the assignee takes over the rights and obligations under the contract, and the counterparty agrees to the substitution. If there is a violation of the False Claims Act that implicates a contract that is either later assigned or novated to the buyer, the seller or the buyer can be liable. So that's an important point that kind of affects any type of structure here.
The one thing that I would comment on is you'll see in the sort of second bullet, you always want to pay attention to whether the transfer of an asset could be construed as a fraudulent conveyance. So I've gotten questions before in M&A deals where the buyer wants to purchase all of the contracts owned by, this would be a government contractor buying another government contractor. They want to buy all of the contracts held by the seller, but they don't want to carry any of the liability. And so they've worked it out so that maybe they have subcontracts, for instance, so that they're not actually dealing directly with the government, and the novation isn't going to go directly to the contracting officer. You have to question whether that asset would constitute a fraudulent conveyance. Is the seller trying to avoid a debt or an obligation to the government by selling the only thing it has that's worth any value? If the company is essentially would be defunct or would be insolvent without that contract, are they trying to sell that contract in order to get rid of that liability and say, well, now you can't come after us, government, because we don't have anything to give you? In such circumstances, that fraudulent conveyance can actually bind both companies, both the buyer and the seller. Each state has a different concept of what a fraudulent conveyance is. They, for instance, some states call it a statute of Anne, which comes from Old English law, like much of the United States laws do. And so you always have to consider the possibility, is this sale happening because they want to avoid liability? Because if that's the case, that liability, even if you bargain away the transfer of the liability, it still may pass with the transaction.
Good point.
All right, so couple extra considerations specific to government contractors. So if the buyer assumes performance of the seller's federal contracts, which is pretty common in innovation, that's one of the main purposes of an asset sale. You don't buy a contract that no longer has any performance because it would have no value. If the buyer is assuming performance, then an ongoing or continuing FCA violation, such as improper billing or improper certifications, that is not immediately corrected and disclosed to the government, could result in liability for both the buyer and the seller. The seller is always going to have that liability. Unless somehow the government releases that liability is going to hold to the seller because they committed the FCA violation before the transfer. But the buyer may absorb some of that liability for continuing an FCA violation after the transfer. So one example I'd give you is, let's say that a large business decides to acquire an 8A minority-owned business through either a stock sale, or they buy an 8A set-aside contract through, or I guess an 8A set-aside vehicle as part of a joint venture. We're getting a little complicated with the sale here, but if the underlying contract was procured by fraud, for instance, the company was not a viable or a certified 8A, or they were out of compliance with the regulations at the time they obtained that contract at the appropriate trigger point, then that liability, if the buyer continues to perform on that contract that was procured by fraud, that buyer may well be liable under the False Claims Act for continuing a contract that was ultimately procured by fraud. You would probably see it more on a circumstance where John Smith is an employee on the contract and they are billed at a certain rate based on a fabrication of their qualifications, like they're billed at engineer 3 instead of engineer 2. They don't have the actual educational qualifications to be billed at engineer 3. The buyer may not recognize that and will continue to bill the government for the improper hourly rate for that individual. That is the kind of thing that could lead to future FCA obligations for both the buyer and the seller. So when we're talking about purchasing of contracts, or even purchasing of a business that does business with the government, there's the mandatory disclosure rule, and it's found in FAR 52-203-13. At least that's where it is right now. We could see it somewhere else under the FAR overhaul that's currently undergoing revision right now. The mandatory disclosure rule, and I'm going to talk a little bit about this in the future, is a requirement for all government contractors that they disclose to the Office of Inspector General and the contracting officer anytime they have credible evidence to believe that a False Claims Act violation has occurred. And so when there is a purchase of a company or a purchase of an asset, the buyer can notify the government almost immediately upon discovery of an FCA violation and mitigate some of their risk. That means, however, that some of the value of that contract may go away. It may result in the termination of a contract. And so this is a strategy you would want to talk about with lawyers during the transaction process, particularly if you learn of the FCA violation during the due diligence process. But you want to make sure that you're aware of the mandatory disclosure requirement and use it to your benefit to potentially avoid, if you're the buyer, liability for an FCA violation, because you would have the opportunity at that point to cure any problems. And the last thing I wanted to specifically talk about is novations. Novations of government contracts specifically require the buyer to assume the liabilities of the seller with regard to the contract in question. And the reason that is important is because the government has to have someone to go after for contract violations, improper invoicing, anything that happens prior to the date of the sale. A novation essentially creates a new contract between the buyer and the government. But that prior contract, although it no longer exists for purposes of existing business, the government no longer has the contractual relationship with the seller, and they need a vehicle or an entity to go after to recoup money on that contract or to enforce performance. And so that's why the novation FAR clause requires the buyer to take on the liabilities and the seller to be released by the government. The buyer and the seller can still work out, and we'll talk about this a little bit later, indemnification and clawbacks and things like that to protect the buyer. But ultimately, the government will only be able to go after the buyer, not the seller, in the event of a novation and they discover some sort of clawback is necessary later. So with all of that sort of background, let's talk a little bit about the types of FCA violations that can arise that should be contemplated as impacting M&A transactions. So first, we have a false presentment claim. That's where a company knowingly presents or causes to be presented a false or fraudulent claim for payment or approval to the government. So we're going to harken back to that earlier slide and talk about what is false, what is a claim, things like that. And the second version is false record claim. That's when a company knowingly makes, uses, or causes to be made or used a false record or statement material to a false or fraudulent claim. Now, these are two very similar concepts. And some examples here would be submitting a false invoice, the example I gave with John Smith, where he's engineer 2 qualifications, but he's billed at engineer 3, submitting inflated hours that were not worked. For instance, on a labor hours contract, you just bill every employee 8 hours a day, 5 days a week, and your invoice has 40 hours. Well, if that person left 4 hours early on a Friday and you still billed the government for it, depending on the terms of your contract, that could be an FCA violation. I've seen cases where there was an inflated profit margin, where the government had negotiated a profit margin or a fee of 4% with the contractor, but the contractor actually billed at 5% and no one caught it. Billing for unallowable costs, shifting expenses to a government contract, even though those expenses were potentially incurred for private sector work, or submitting an invoice with a false certification, either express or implied, something like on a construction contract, sometimes you have to certify that all subcontractors have been paid or will be paid out of that money, but you're so far in arrears that you know that the invoice is not going to cover all of your subcontractors' work. That would potentially be a false certification. We then have the super complicated concept of a reverse false claim, where a company has possession, custody, or control of property or money that is used or to be used by the government and knowingly delivers or causes to be delivered less than all of that money or property, or knowingly makes, uses, or causes to be made or used a false record or statement material to an obligation to pay or transmit money or property to the government in order to avoid or decrease an obligation. Essentially, you're holding on to money that you are not entitled to receive. Now, let's say this one is pretty common. Let's say the government, for some reason, overpays on an invoice, and for whatever reason, everybody discovers it a few weeks later, but the contractor doesn't notify the government, or the government reaches out and says, we believe we've overcharged you, and you present some sort of false argument to hang on to that money for some reason. There's also a somewhat famous reverse false claims act case where the government accidentally transferred to a government employee um, their 2 week salary of $15,000, but they added a zero and sent him $150,000. And I guess that wouldn't have been a 2 week salary. They were making a payment of some sort for 15,000, but actually paid 150,000. And the person quit their job, never returned the money. Well, they became liable under the False Claims Act rather than just clawing back that money. It was a mistake. If they had returned the money, never would have been a False Claims Act violation. It was the absconding with the 150 that made it a false claim. Fraudulent inducement is when a company engages in a scheme or a series of acts that ultimately leads the government to award a contract, usually under false pretenses. It's usually related to a false certification as part of the bidding process, like for instance, bidding on an 8A contract when you're not a qualified 8A. If that contract is awarded, the entire contract itself is procured by fraud, and it is determined that all of the invoices submitted under that contract would be false claims. And then we have conspiracy, which is essentially when two or more companies or people act together to do any of the four above bullets. So, the key point there is that they have an agreement of some sort to engage in a course of action, and ultimately someone, one or the other, takes an action to perpetuate that fraudulent scheme. When that is done, all of the parties to the scheme can potentially be liable under the FCA. Some other factors to consider about common types of FCA violations. So during contract performance, you could have violations of a statute or a regulation, or violations of contract requirements. You'll see this frequently in small business set-aside contracts that have limitations on subcontracting requirements or performance of work requirements for a joint venture. You also may have industry-specific regulations. So, for instance, if your company is receiving Medicare or Medicaid payments, and let's say you're doing home healthcare work, if the home healthcare workers do not speak English fluently, you could violate various CMS regulations, and that could create a False Claims Act violation. I happen to know of that one because it's come up before, but there are going to be industry-specific regulations in every industry that can lead to FCA liability for companies involved in those industries. There could be cybersecurity violations of the FCA, and there has been created by the Department of Justice a civil cyber fraud initiative to hold government contractors liable where they are failing to meet their cybersecurity requirements. Those cybersecurity requirements are generally set forth in your contract, but they may be set forth in the rules and regulations of a specific agency, for instance, related to data privacy or where information can be stored. One really important thing to remember about cybersecurity is the contractor itself has cybersecurity obligations. And of course, the contractor has to be responsible for complying with those. But the government also has cybersecurity requirements, such as preserving government employee data or Medicare, Medicaid recipient data. A contractor can violate the FCA not only by violating their own cybersecurity compliance requirements, but also by failing to perform in a way that allows the government to meet the government's cybersecurity requirements. So for instance, if there is a misrepresentation about where certain data was being stored and the government has an obligation to store that data in a certain secure manner, the violation could be both on the contractor's obligations and the government's obligations, sort of double dipping. Now, it's not going to change the amount of damages the government has incurred, but it's not, you might be strictly compliant with your own cybersecurity requirements, but not the government's, and therefore creating FCA liability either way. Set aside ineligibility is a very common FCA claim these days. You could see ownership and control issues of a small business. You could have incorrect size calculations, net worth or asset thresholds for the 8A program or other woman-owned small business program. You, excuse me, you could have negative control of a large business, or let's say you have a service-disabled veteran-owned small business. The non-disabled veteran may have negative control because your contract or your operating agreement is not properly drafted. And you could have engaged in changes to your corporate documents or changes to your management structure after being approved for that set-aside program that could change your eligibility. Antitrust issues are also a big priority for DOJ right now. They've created the Procurement Collusion Strike Force, which is designed to weed out collusive bidding for government contractors or any type of antitrust violation that affects federal funds. That would be things like bid rigging, price fixing, collusive bidding, exclusive dealings. So if a prime contractor has an exclusive relationship with a subcontractor, or a manufacturer, for instance, or supplier of a good of a product or material, restricts who can purchase that product or material, you could end up with an improper exclusive relationship. And what we're really looking at here is the government's price point inflated because of some sort of relationship between companies within the same industry. And although this isn't really an antitrust issue, I do want to talk very briefly about the Anti-Kickback Act, because a lot of whistleblowers have been raising it as an antitrust violation. The Anti-Kickback Act, as it relates to government contractors, is invoked when something of value is provided by one entity in exchange for an award of a government contract or a government subcontract. Typically, we're talking about significant amounts of money that are going to trigger the Anti-Kickback Act, but there are a number of whistleblowers out there who are currently pursuing a theory that if a subcontractor identifies a contract for the prime and the prime bids, and in exchange they give a subcontract to the subcontractor after award, that's a kickback. It's not. That is not a viable legal theory, but we're seeing it a lot now. And one of the important things to remember is just because something's not an FCA violation doesn't mean it's not going to be costly to the company to defend it. So if you have these potential exclusive relationships, or if a company, a subcontractor brought a contract to the prime contractor because maybe they were the incumbent, it's something to think about during the due diligence project or process to determine whether the value of the sale really meets with the amount of risk you might be facing later. And then a couple of more recent FCA type violations. We have the COVID-19 relief program fraud. DOJ has created a fraud task force that includes not only PPP loans and EIDL loans, the restaurant relief fund, the shuttered venue operators grant program, but it also relates to companies that sold products specifically targeting COVID-19, citizens related to COVID-19. So for instance, if you're selling alcohol-based hand sanitizer or masks that were not compliant, that can result in a False Claims Act violation. And then finally, just a couple of months ago, the Civil Rights Fraud Initiative that was announced essentially is how the government is trying to use the FCA to tamp down what it sees as some political priorities, such as DEI programs, transgender bathroom use, transgender sports participation. Although those issues are sort of targeted at colleges and universities, the implications of the very broad civil rights fraud initiative could lead to rank and file government contractors facing FCA liability, or at least FCA claims, because they are sued by an employee, for instance, for employment discrimination. So all of those things are potential vehicles for FCA liability and should be considered in an M&A transaction. Another important factor is the amount of money that is in play for an FCA violation. treble damages are required, and that is determined in reference to the type of claim pursued. So I've put a few examples up there. If ultimately you're billing for unallowable costs, the value of the damages in that case is 3 times the actual unallowable costs. But let's talk about the ones that don't that feel particularly punitive. If you are awarded an 8A set-aside contract or a hub zone set-aside contract, a woman-owned small business set-aside contract, and the theory is that you are not eligible for that contract in the very beginning, the entire value of the contract, the revenue value of that contract, is the amount of damages allegedly suffered by the government. So you could have a contract with revenues of 7 million. The damages the government is going to claim is 21 million. But that doesn't factor in that you might have a 3% profit margin on that 7 million. And ultimately what you're paying out of pocket for an FCA violation that we're talking about many, many times the actual profit margin. There are also mandatory penalties that are imposed. For every single violation, you'll receive a mandatory penalty of 14,308 to 28,619. Those numbers are adjusted on an annual and sometimes semi-annual basis. When I talk about per violation, I'm talking about the individual invoice itself. And when a whistleblower is involved, you could also be impacted by attorney's fees and costs paid to the whistleblower. And then finally, of course, your own defense costs. FCA litigation is extremely expensive. And that liability can last for a very long time. The statute of limitations on an FCA claim is 6 years from the date of the fraud, or 3 years from the time the government official charged with investigating the fraud, that's the Department of Justice, knew or should have known about it. But it's never longer than 10 years. That said, I've seen the government try to argue that the statute of limitations actually is longer than 10 years. So don't even take that as a hard line. They're going to try and blur that line as much as possible.
Thanks, Matt. Okay, so now we're going to talk about how a buyer can protect itself from risk prior to closing. And there are 5 main vehicles of protection. One way a buyer can protect itself is to conduct thorough due diligence on the target and the sellers. Another way is to negotiate reps and warranties in the purchase agreement that are tailored towards the risks that are uncovered during diligence. Another way is to negotiate an indemnity package that is reflective of the risks that are identified during diligence. A fourth way is requiring an escrow or a holdback that contains a percentage of the purchase price that's reflective of the potential liability exposure to the buyer because of the risk and the liabilities in question. This is often called putting a box around the liabilities. And the fifth is for a buyer to obtain insurance that covers the risk. And we'll kind of go through each of these different buckets of protection.
Sure. So why don't I start with some general sort of FCA red flag issues for due diligence. And these are categories of information or documents I recommend potential buyers to request during the outset, like sort of the very early stages of an acquisition, because you want to know what your liabilities might be if you're going to go forward with the entire transaction. And these are types of things like you want to know whether the government has engaged with that company at some point to talk about a potential FCA violation. And it may not be quite so obvious because the government may not use the words False Claims Act or FCA when talking about these questions, but they may have issued a subpoena. You'll see what's called a civil investigative demand, or CID. You may also have criminal or civil inquiries. Sometimes they can be informal. For instance, you might get an email from the contracting officer asking for data. You might get contractor discrepancy reports or other informal requests for information. Frankly, a CDR would be pretty formal anyway. Or you might just get a request for a meeting with the government. All of this is something you should be asking for. You should also be asking for sealed and unsealed litigation. False Claims Act matters are sealed on the front end. Now, some sellers will say, oh, I can't give you sealed information. They can't give you documents in a sealed litigation, but they may be able to provide information that is not sealed, like the civil investigative demand that existed before the sealed litigation was started. You're also going to want administrative and regulatory matters, like inquiry and challenge documents like show cause, suspension, or debarment letters, size or status protests for government contractors, cure notices and responses, contract termination notices, and documents related to any bid protest. So why does it matter if you received a contract termination notice on a contract that's not subject of your transaction? Because there may be key points in that termination that tell you that there's some sort of other issue that might affect other contracts in the future. And then documented employee complaints, usually, hopefully from HR, including any reports made to an ethics hotline or portal, and records of all actions taken in response to those complaints. All of that is going to be key to identifying potential red flags that are more likely to lead to an FCA violation or indicate that an FCA violation has already occurred.
That's right. And for all the reasons that Matt just highlighted, you could tell the due diligence is really the heart of a successful deal, even a small transaction. I think it's worth noting that there's usually two phases of due diligence. There's usually what's called like a red flags diligence phase. This is the diligence that's done very early on in a deal, usually during the LOI phase. Um, if a buyer suspects there might be FCA liabilities or risks, I think it's appropriate to dig into this type of diligence as early on as the red flag phase. There's also the LOI phase, which usually happens after a letter of intent or a formal LOI is signed. That's when a buyer will come in and do its full-fledged diligence. So it will go in and analyze all government contracts, take a look at all of the target's other non-government contracts, its permits, its insurance. And really the purpose of doing full-fledged diligence is to really make sure that the buyers, how the buyer values a company from the LOI phase is really reflective of the value of the company based on what it's learned about the target. It also, another purpose of doing diligence, even from the LOI stage or even earlier at the red flag stage, is so that the buyer can really understand what its post closing obligations will be, particularly with respect to any contracts it's assuming. So it'll want to do, as part of its diligence, it'll want to review the contracts and understand the billing and the cost reimbursement requirements. It'll want to understand if there's any limitations or restrictions on the buyer's actions after those contracts. And it'll want to understand, what it needs to do, particularly if it's a contract that involves innovation. What does the buyer need to do once it steps into the seller's shoes and really assumes that contracts and takes over those rights and obligations? So due diligence it's an important part because it helps the buyer negotiate the reps and warranties in the reps and warranties in the purchase agreement and the indemnity package, but it also really helps the buyer uncover the risk and understand how it needs to operate the business after closing.
And so just a couple of other things on statutory, regulatory, and contract compliance. Kristen just covered a lot of this. One thing that jumped out at me, though, was I had an M&A deal a few years ago where the goal was to purchase a contract vehicle that had a ceiling value. And as it turned out, there had been a lot of surge work in the year prior, and during the transaction, a lot of that ceiling had been eaten up. Well, the value of that contract dropped dramatically because there was no guarantee that this specific agency was going to increase that contract ceiling after novation. I've also seen M&A transactions fall apart because the agency is a very difficult agency to work with as far as novations are concerned, particularly on large vehicles where they may have 20 bidders already for various task orders. If they're just swapping out one, the agency may feel that it's better just to live with the 19 remaining bidders as opposed to swapping out the 20th. So those are other things that you may want to take into consideration a little bit. Is this something that is going to bring the buyer value down the road? And if it's not going to bring as much value, adjust the purchase price as a result. So a couple of things you might also want to ask for on some of the other FCA issues I raised earlier. On cybersecurity issues, you want to understand what the cybersecurity requirements are for each contract so that you know that you can comply. For instance, if you're purchasing a company that is required to be FedRAMP compliant, are you able to perform in a way that makes sense for your transaction in compliance with FedRAMP obligations? And like Kristen said, you need to understand the go forward obligations post closing to ensure that the buyer is ready to perform in compliance on day one, because that's what the government is going to expect. That as soon as this novation goes through, contract performance is going to begin, and the new contractor is going to be ready to do so. On the antitrust issues, you'll want to review subcontracts, vendor agreements, purchase orders, discount programs, and determine whether there's an exclusivity requirement in any of these agreements that might be against industry standards or that potentially is under review by not necessarily your transaction, but other transactions by the Department of Justice. For COVID-19 programs, particularly programs related to the distribution of money, like the PPP loan program, you're going to want to have seen their initial application, their forgiveness applications, any financial audits or disclosures that were provided, compliance correspondence and records that they may have preserved, continuing monitoring correspondence, communications with the government, and whether there's been at any point a challenge to the company's eligibility. And then on civil rights issues, you're going to want to look very closely at employee lawsuits, complaints, documents related to risky terminations, and whether the company has any disgruntled. And I put disgruntled in quotes because what categorizes as a disgruntled employee changes from company to company, and often it's the disgruntled employee who's actually just making the company understand that there is an FCA violation, and they're categorized in this sort of disgruntled employee area, despite the fact that they're actually trying to help the company out. So you want to be able to review all of these, but also take them very seriously, because that's where the whistleblowers are often coming from.
Great. So a second way a buyer could protect itself pre-closing from risk is to negotiate reps and warranties that are really reflective of the seller's business and the risks that are uncovered during diligence. So for example, if a buyer's counsel or a buyer discovers that certain permits are very important to the operation of the target's business, the buyer might want to insist on a full rep and warranty that the target's business is in compliance with those permits. And so then after closing, if the buyer learns that that's no longer the case, then they would have cause for a breach of warranty claim and get a remedy for breach of that particular claim. I should note that some key reps that cover FCA risk that buyers will usually insist on having in a purchase agreement is a rep that says no violations of applicable laws, including the FCA, a rep that covers no pending or threatened investigations or litigations, requiring the company to rep at accurate financial statements and billing practices in compliance with government contract rules. There are a couple notable risks and limitations to remedies through reps and warranties. One is that the seller can only rep and warrant what it is aware of, right? So if a liability is present and neither the buyer nor the seller can identify it, the buyer won't have any recourse against the seller for a breach of a rep. So we'll have to turn towards other remedies to be made whole. Also, if a buyer can be indemnified by the seller, even if a buyer can be indemnified by the seller or a target for a breach, sometimes the seller isn't anywhere to be found after closing, or it's insolvent. So it won't have sufficient funds to cover the buyer's losses. So again, the buyer will be required to turn towards other remedies to be made whole.
One last thing I would say is it's never easy to get into post-closing litigation between a buyer and a seller. Even if you found the seller, even if the seller still has money to pay it, you're getting into an entirely separate litigation. It could be hundreds of thousands of dollars in costs. there's no guarantee. You might have to go to trial. There's a lot of risk there. And so ultimately, we're giving you some solutions to think about during the transaction, but nothing is going to be a silver bullet. Nothing is going to protect you 100%. And when you are thinking about your risk tolerance going into an M&A transaction, you have other avenues where you can think about, how do I mitigate this risk that I might have to be in a litigation for a couple $100,000 or several $100,000 later. And one of those really effective solutions is indemnification clauses, because they're a little tougher to get around. So I'm gonna I'm gonna let Kristen sort of fire up here, and then I'm gonna talk a little bit about a very important indemnification provision for government contractors.
Good segue. So the third way a lawyer can, or a buyer can protect itself pre-closing from risk is through a solid indemnification package. And really the purpose of an indemnification package is to shift the financial responsibility for breaches or liabilities to the other party. And so the structure of an indemnity package usually consists of, a buyer agreeing to indemnify the other for losses arising from a breach of a rep, pre-closing violations, including VCA violations and tax violations, and known or unknown liabilities. And so you can usually you can have an indemnity package that's in favor of a buyer, and also a mutual indemnity package that's in favor of the buyer and seller. There are limitations, or you often see limitations on an indemnity package. So, for example, an indemnity might have caps on the aggregate amount either party is required to pay out. And so this could be problematic when there's an FCA claim, because FCA claims or even fraud-related claims might be carved out from the caps due to their severity. There's also baskets and deductibles that can be negotiated. And that means that the indemnifying party doesn't have to pay the other party until the damaged party suffers X amount in losses. There's also survival period. So when a rep expires, when a rep expires, the time the indemnity has to file the indemnity claim is tied to the breach of the rep goes away. So when the rep expires, then there goes the buyers or the sellers, if there's mutual indemnities, remedy with respect to the indemnity package. Yeah, you should also, one note about losses too, is if you're negotiating an indemnity package, you should think about the losses that are covered. When you're a buyer, you want to make sure the definition of losses is very broad. So it covers attorney's fees. It covers, claims of restitution, criminal penalties, costs of investigation and defenses. Because with FCA claims in particular, as Matt's aware, they can add up very, very quickly, and you want to make sure that you're indemnified for all different kinds of losses.
Yeah, there's another aspect of the FCA that you all are going to turn your head to the side and wonder what I'm talking about. But when you have these indemnification clauses, indemnification is a creature of sort of two buckets. It's a creature of contract first and foremost. And under that contract, you're only indemnifying for exactly what you agreed to indemnify for. That language of that indemnification clause is really, really important. And so on the second bullet point, that's why I'm saying you should make sure that your indemnification covers the submission of false claims, things like defective pricing, false statements made to the government, whether by the company itself or by an employee. And you also want to cover, particularly if you are purchasing a small business that does government contracting work, the Financial Institutions Reform, Recovery, and Enforcement Act, or FREA. Now you might think, why do I need to worry about financial institutions? I'm not a bank. But DOJ has attempted to apply FREA to companies that have allegedly defrauded the Small Business Administration as part of the set-aside programs. And the reason they're doing this is because the SBA itself has loan programs. Under the 7A loan program, the SBA is technically a lender, a financial institution that makes money available to small businesses. And so if a company, even if you're not taking out a 7A loan, if a company is allegedly misrepresenting to the government its qualification for a small business set-aside program, the Department of Justice has alleged violations of FREA. And FRIA is a penalty statute. So if you violate FRIA one time, I believe that it's a $1 million penalty. And if you violate it multiple times, it's a $10 million penalty. So these are the types of things you aren't able to control if you're purchasing a company. You aren't able to control representations made prior to the transaction. You may not even know that those representations were made. They only come out later. So you want to specifically cover things like the FCA and FRIA to make sure that in the future you're adequately protected. The second bucket of indemnification I talked about is common law indemnification, and sometimes it's referred to as indemnification and contribution. It doesn't exist in every state. It's sometimes hard to prove. Sometimes it's a lot easier to prove. But it's you want your indemnification to be established by contract, because it is very easy to fight over the scope of an indemnification under common law. And what we're talking about is this equitable doctrine that courts impose when, let's say that you're in a car accident, a car accident where the car in the back rear ends the one in the middle, which rear ends the one in the front. The one in the front got hit by the one in the middle, and so they sue the one in the middle. The guy in the back is like, I didn't do anything, I was stopped, but the car in the back hit me, so they file for indemnification against the car in the back. The reason that the common law allows for indemnification like this is because prior to that moment, those three never had a relationship. But in a transaction where there's an M&A transaction, the court is going to presume that you all are negotiating at arm's length, and that the only indemnification you're getting is exactly what you wrote into your agreements. And if you didn't write in your agreement, the assumption is there was no agreement to indemnify at all. So that's why it's really important to create this robust indemnification package so that you don't have to call me after the transaction and have me sue someone for common law indemnification, because that's going to be a tough one to win.
Yeah, that's a good point. And one other thing I wanted to note on the indemnity is it's sometimes important to have other remedies on the shelf, particularly for a buyer, and not just an indemnity package. Because if a buyer's sole remedy is to go after a seller and get indemnified for a breach of rep, for example, and the seller becomes insolvent, all of a sudden the seller is left without being made whole. You can't get blood out of the rock, that kind of situation. So another layer of risk that the buyer can think about, in addition to indemnity and some of the other remedies we're talking about, is a holdback. So really what a holdback, or sometimes called an escrow, is when a buyer sets aside a portion of the purchase price to cover post-closing claims or cover risks that are identified during the diligence process. Really, it's a way for a buyer to put a box around the liabilities, estimate the likely damages that could come from this risk, and then cover that amount and put it in an escrow fund. An example is if a buyer, sets aside purchase price funds to cover risk related to a pre-closing litigation. The escrow funds might be released once the litigation is dismissed or settled, so that risk dissipates essentially. And then any escrowed funds that are released back over to the sellers could exclude any kind of litigation costs or costs that the buyer has to incur, basically, to take care of that risk. There's different types of escrows or holdbacks. You could have an escrow that particularly covers a known risk. So a litigation escrow, for example. You could have an indemnity escrow. So it's really a pot of funds that's set aside, and it's just there so that if there is an indemnity claim, the buyer can tap into the funds in the indemnity escrow instead of going directly after the seller and just kind of praying that the seller has money to pay for those indemnity claims. But it really is, it's a benefit because it provides an immediate source of recovery without litigation. There is a risk to a holdback, like a risk to all these other remedies. If an escrow amount is too small to cover the full extent of a liability, like an FCA liability, or if the buyer did a bad job putting a box around the liability and estimating the likely amount of the damages, the buyer might not have any recourse. The buyer would have to kind of tap into other funds or look into other recourse outside of the funds that's set aside to cover that risk. Also, escrow periods typically last 12 to 24 months. That's not set in stone. The escrow period could be negotiated, but if an FCA investigation, for example, or any other kind of litigation arises years later and the escrow funds are released, then the buyer has to use other means to be made whole, whether that's litigation, whether that's tapping into an indemnity package or other means. So if a buyer knows that there's a really meaty risk or something that could go beyond the escrow period, they should really think hard and negotiate longer survival periods.
And I had talked a little bit about novations earlier and how the government requires the buyer to take on all the liabilities of the seller. A holdback fund would be a really good way to sort of mitigate that risk for the buyer, and hopefully get paid back in the event that there's a liability that was caused by the seller prior to closing.
Yeah. And so the last remedy or pre-closing remedy that the buyer can use to mitigate risk is insurance. This isn't the immediate go-to, mechanism, but it is available and it's becoming more and more common just because you can insure, you can insure everything these days. There might be a premium to it, but you can insure pretty much anything. So a buyer can purchase insurance that covers FCA violations. It's sometimes hard to come by and it can be expensive, but that is an option. A buyer can also buy or cause a seller to purchase error and omissions insurance. So this is insurance that covers against claims of negligence or failure to perform professional duties. So in FCA world, it might apply if an FCA claim stems from an alleged negligent representation or billing errors. A buyer could also buy an EPL insurance or employee practice liability insurance. That's coverage that protects businesses against claims made by employees or sometimes even job applicants for alleged violations of their legal rights in the workforce. And as this relates to the FCA relevance, this might apply if the FCA claim involves a whistleblower retaliation, for example. And so the big benefit with insurance is it reduces the need for seller indemnities or escrow and covers unknown risks. And if a seller, for example, comes over and becomes an employee of a buyer, and there's a breach of a rep, or a buyer wants to tap into its indemnity package, sometimes it can be kind of awkward to get that from the seller who's now your employee. And so insurance kind of becomes the middleman so that the buyer can go get coverage through an insurance policy and not have to, deal with disputes and kind of awkward relationships with the seller if the seller is still involved in the business in some way.
All right, so I think moving on, there are a couple things that buyers can do to protect itself post-closing.
Mm-hmm.
You want to tackle those for us?
Yeah. So one way a buyer can protect itself post-closing is just through a compliance and integration plan. So a buyer can, for example, identify the gaps in the target's compliance program, especially in high-risk areas like government contracting, billing, and FCA exposure. It can, align the target's compliance policies with the buyers and nix, any non-compliant protocols. Another way it can protect itself is through training. So it can train employees on FCA obligations, whistleblower protections, and anti-kickback and fraud prevention. And just make sure that its employees are smart on the things that they need to do to be compliant. I would say another, last recourse post-closing strategy is litigation against the seller. Um, Usually it's not wise for litigation to be kind of a proactive measure, but it's a last resort. So if the seller breaches reps, warranties, and indemnification obligations, the buyer may sue to recover losses unless the purchase agreement, for example, says your recourse is limited to the indemnity package. Should note that fraud claims, regardless of what the purchase agreement says or the limitations on an indemnity package, you usually can go to litigate fraudulent claims. You're not limited to only the indemnity package or the contract for recourse there. I would say post-closing covenants can also be enforced through litigation. They're not typically limited to the contractual limitations or an indemnity package or the rights for breaches of covenants or breaches of warranties. I'm sorry. But I would say the best practice is to use litigation as a backstop, not the primary protection. It's a good idea to combine remedies, so combine escrow funds for immediate recovery, insurance to cover gaps, and then have a strong indemnity language for fraud carve-outs for litigation. And then of course, document all breaches and maintain evidence for any potential claims, whether in court or claims, indemnity claims under the purchase agreement.
Yeah, that paper trail is critical, whether it's litigation, whether it's an
Mm-hmm.
FCA investigation, no matter what, maintain all of the documentation. The thing I would add to that is during the due diligence process, during the closing process, while you're negotiating the agreement itself, you've identified some of these FCA risk or other potential indemnification risk and things like that, claims that may come up in the future. And you should keep those front of mind. I call them pain points because they could be very painful post-closing, but be ready. Come up with strategies during the transaction process to mitigate the risk of those issues and to be ready for them when they happen. And some of the things that you can look at are, size and status recertifications if you're buying a government contractor that's a small business. Keeping key employees as long as you can, but ensuring there's a checks and balances, because the key employees, if you're going to face a violation in the future that was created by the key employee is the person who probably was responsible for it. So you want to make sure that there are checks and balances and you're supervising them and you're not giving them carte blanche to do whatever they want, because they might just perpetuate a False Claims Act violation that existed before. But part of that sort of prepared to go on day one is creating compliance checklists and forms that keep you in line with requirements as you're taking over responsibility for a new company or an existing government contractor. Again, you've got the mandatory disclosure. That is a protection for buyers. They can report to the government. You can even require the seller to make a mandatory disclosure as part of the transaction. And if you're going to do that, um, you know, if they're motivated enough to sell, they'll make that mandatory disclosure and they'll be the ones taking on the responsibility. And you're then essentially carving out whatever the liability is going to be with the government. You can get cooperation credits for the government for making a mandatory disclosure after the purchase of a company. And essentially what they're saying is that the government will either not hold you liable for something that happened before you are the owner of the company, or they will substantially reduce your liability. You're probably not going to avoid the attorney's fees incurred to defend against the investigation or the liability, but at least they won't be coming after you for the full cadre of remedies that the government can come after you for for an FCA violation. And then, Kristen touched on this, but you've got litigation against the seller. I highlighted the common law contribution indemnification. I wish there was a different color, a lighter color that dissuades you from doing it, because it's really tough to win when you have an existing contract that has indemnification in it, but it is a possibility. The last thing I wanted to talk about, and we're a couple minutes over, but I promise we're wrapping up, is rescission. So sometimes you have no idea about a violation. Maybe it's not something that came up in due diligence. Maybe there is a misrepresentation in due diligence, and suddenly you're facing some sort of FCA violation, but it has come up immediately after closing. You could potentially claw back that entire transaction, and you could make a demand for everybody to go back to the place they were immediately before the transaction was commenced, or immediately before closing. It's an extraordinary remedy. It's very difficult to get. Usually a court has to order it, but you have to take that action immediately. This is not a wait and see thing. If this is a big liability that you think affects the company's ability to go forward in business, you might want to consider rescission, but you've got to make that call right away, because if you wait even weeks to make the call, you've probably waited too long to rescind that transaction, because you've started performing and you've acted as if the transaction was consummated and started performing, if you've paid out money under the contract, things like that. So that's the last thing I wanted to say. Just, hopefully today's discussion set you up for success in a future M&A deal. We didn't get to any of the questions. We will reach out to you. We get a log of all of the questions, so we will reach out to you with some commentary there. We really appreciate you joining us, and hope to see you on a future webinar. Kristen, you want to wrap up for us?
Yeah, so I think with everything that we've said today, the big takeaway is the best defense against FCA exposure, particularly in M&A transaction, is proactive strategy, right? So identify the risks early, either in the red flag stage of diligence or, the LOI full-blown stage of diligence. Allocate them clearly in the deal by reps, indemnity package, escrow, et cetera. We talked about all the remedies that the buyer has, and really reinforce compliance culture post-closing. So FCA risk doesn't end at closing for all the reasons why we talked about today. And so we highly encourage, buyers to combine thorough, smart diligence, strong contractual protections, and robust post-closing compliance programs to safeguard their investments. So with that said, I think we're wrapping up our presentation, but as Matt noted, if you have any questions about what we talked about today, feel free to reach out to us, email Matt or I, and we'd be happy to get back to you with about your questions.
All right. Thank you all very much for joining us, and we'll see you soon. Have a great rest of the week.